Imagine this. You're involved in an air travel incident. You suffer loss, and the law entitles you to compensation in foreign currency. But years pass before your case reaches judgment, and the exchange rate has changed drastically. Should your compensation be valued at the rate that existed years ago when the incident occurred, or at today's rate, reflecting the true economic reality? This single question has created confusion, inconsistent outcomes, and heated courtroom battles across Nigeria's aviation industry until now. In a landmark 2025 judgment, the Supreme Court finally delivered the definitive answer in Mr. Femi Anibaba versus Dana Airlines and Stacey Violet Sellers, SC/CV/1191/2022. For the first time, the Apex Court clarified exactly when foreign currency damages should be converted into Naira under the Montreal Convention. This is not just another aviation case. It reshapes compensation law, impacts airlines, insurers, and litigants, and protects victims from the crushing effects of inflation and currency depreciation. Stay with us as we break down what the Supreme Court decided, why it matters, and how this ruling now ensures fairness, real value, and true justice in aviation compensation claims. If you're loving this already, go ahead, like the video, hit that subscribe button, share with someone who needs this, and tap the notification bell. Drop your comments on what topic you'd love to see next. Your suggestion could be our next video. Supreme Court finally clarifies conversion date for foreign currency claims in air transport cases using case citation SC/CV/1191/2022, Mr. Femi Anibaba versus Dana Airlines Limited and Stacey Violet Sellers, Supreme Court 2025. In the aftermath of air transport accidents or incidents, one recurring question in Nigerian aviation litigation has been, at what date should damages claimed in foreign currency be converted to Naira? Should it be the date of the accident or incident, or the date of the final judgment? This question has now been clarified by the Supreme Court in Mr. Femi Anibaba vs. Dana Airlines Limited and Stacey Violet Sellers, SC/CV/1191/2022, decided in 2025. The case in brief tells us how Mr. Anibaba sued Dana Airlines under the Montreal Convention, seeking compensation in foreign currency for loss and damages sustained. The airline argued that if the judgment were to be enforced in Naira, the conversion should be based on the exchange rate at the time of the accident, which occurred years earlier. The plaintiff, however, contended that the proper conversion date should be the date of judgment, reflecting the current exchange rate to ensure the award retains its true value at the time of enforcement. The Supreme Court's decision so far was that the Supreme Court agreed with the plaintiff, holding that, under the Montreal Convention, the applicable date for converting damages claimed in foreign currency into local currency is the date of judgment, not the date of the accident. The court reasoned that this approach aligns with the principle of restitutio in integrum, that is, the injured party should be placed, as nearly as possible, in the position they would have been if the wrong had not occurred. Basing the conversion on the accident date, given years of inflation and currency depreciation, would amount to partial restitution and unjust enrichment of the defendant. The implication of the judgment. This ruling marks a departure from the earlier judicial trend where courts sometimes pegged conversion to the date of the accident or breach. The new decision aligns Nigeria's position with international aviation law practice and ensures claimants are fairly compensated in real value, not devalued sums. In essence, the exchange rate for converting foreign currency damages is determined as of the judgment date. This ensures awards reflect current economic realities and protects victims from currency depreciation. Why it matters? For airlines, insurers, and litigants, this case clarifies that delay in litigation no longer benefits the wrongdoer through exchange rate differentials. For legal practitioners, the judgment provides a firm precedent under the Montreal Convention, harmonizing Nigeria's judicial approach with global standards in aviation compensation law. At Tonik Law Partners, we believe this decision reinforces fairness in aviation and cross-border commercial claims. It emphasizes the judiciary's evolving commitment to substantive justice over technical rigidity. The Supreme Court's ruling in Anibaba versus Dana Airlines marks a turning point in Nigerian aviation and compensation law. By affirming that foreign currency damages must be converted at the exchange rate on the date of judgment, the court aligned Nigeria with global aviation standards and reinforced the principle of full restitution. This judgment ensures that victims are not shortchanged by inflation, litigation delays, or currency depreciation. It closes the door to technical strategies that previously favored defendants and places fairness, equity, and economic reality at the heart of compensation awards. For airlines, insurers, and legal practitioners, this is now a binding precedent, one that will influence negotiation strategies, litigation expectations, and compensation calculations going forward. At Tonik Law Partners, we view this decision as a welcome affirmation of justice in cross-border commercial claims. We remain committed to offering clear, strategic, and practical guidance to clients navigating aviation disputes and foreign currency judgments. For more insights on aviation law, currency-related judgments, and enforcement strategy, reach out to our team at Tonik Law Partners, where legal precision meets practical solutions. For more expert insights, analysis, and legal updates that matter, subscribe to our channel and stay connected with Tonik Law Partners, where legal precision meets practical solutions.